Good evening and welcome to Duke University and welcome to Unit 101 Presents Race, Policing, and Activism. This evening's program is part of a larger university initiative titled Race and Anti-Racism and includes a university course being taught this semester that's titled The Invention and Consequences of Race. Many of the students in that course are with us tonight. Welcome to you as well. This event is sponsored by the Office of Undergraduate Education, the Duke Council on Race and Ethnicity, and Duke Law's Center on Law, Race, and Politics. Before I introduce our guests, I want you all to know that we are taking questions via the chat function. Please send any questions that you have throughout the program, and we'll put some of them to the guests at the end of their conversation. It is an honor and truly a pleasure for me to introduce my friend of nearly 45 years and my sometimes partner in what the late John Lewis would call making good trouble. Jerry W. Blackwell is the founding partner and CEO and chairman of Blackwell Burke. Jerry serves as the national and trial counsel for several major corporations, having represented them in federal and state courts in 47 states and internationally. He's an experienced trial lawyer with nationwide experience defending class actions, toxic tort, commercial disputes, product liability, and other high-stake complex cases. Jerry is admitted to practice in the state and federal courts of Minnesota, federal district courts of Michigan, Arizona, Colorado, and Illinois, as well as the United States Supreme Court and the 4th, 7th, 8th, 9th, and 11th Circuits Courts of Appeals. He's a founder of the Minnesota Association of Black Lawyers, and in 2011, Governor Mark Dayton of Minnesota appointed Mr. Blackwell to serve as an at-large member of the Minnesota Commission on Judicial Appointments. Jerry has his law degree from the University of North Carolina at Chapel Hill, where he also received his bachelor's degree in 1984. This evening, Jerry will be in conversation with two of our colleagues from Duke. Trina Jones is the Jerome M. Culp Professor of Law at Duke Law School and the director of the Law School's Center on Race, Law, and Politics. She is a leading legal expert on racial, socioeconomic, and gender inequality, particularly as it pertains to the workplace, and has lectured widely, both domestically and internationally, on colorism, intersectionality, and sexual harassment. She teaches employment discrimination law and critical race theory, law and literature, and race and gender. Joining Trina and Jerry will be another colleague from the law school, H. Timothy Lovelace Jr., professor of law and the John Hope Franklin Research Scholar at the law school. Tim is a noted legal historian on the civil rights movement. His forthcoming book, The World is on Our Side, the U.S. and the UN Race Convention, examines how U.S. civil rights politics shaped the development of the International Convention on the Elimination of All Forms of Racial Discrimination. Professor Lovelace joined Duke's law faculty in June of 2020 from Indiana University, and he teaches American legal history, constitutional law, and race in law. Without further ado, I turn the program over to Jerry, Trina, and Tim.
Thank you so much, Jerry, for joining us today. I think that you agreed to offer a few introductory comments.
I did. First, good afternoon to everybody. I'm very honored to be able to meet and have this opportunity to speak with you, and hopefully before it's finished, it will be more of a conversation this evening. You can ask whatever you want about the George Floyd trial, and I'll answer what I can about the George Floyd trial this evening. Just by way of a background, as Dr. Haney mentioned, we grew up together in the textile mill town of Kannapolis, North Carolina. I attended Chapel Hill undergrad and law school on a Moorhead scholarship, and grateful for it because it was the only way that I saw that I was going to be able to get to college at that time in my life. I went on and finished got my law degree in Chapel Hill, and where I got a chance, maybe Judge Becton is on this evening. If he is, then I'd like to say hello to him. He's been certainly one of the inspirations of my life. But I ended up in Minnesota practicing law thinking I'd only be here for 2 years. I came to work on the Bhopal gas explosion case. And this was an explosion in Bhopal, India, where thousands and thousands of citizens died as a result of an explosion of a Union Carbide plant that released gases that harmed the populace. The government passed a decree that it would represent the victims, and then the government came to the United States to find a law firm to represent the government. So the law firm I came to work with in Minnesota was the law firm representing ultimately the victims in the Bhopal gas explosion case. So I thought I would be here for 2 years or thereabouts, and be back in the Southeast after that. So now here I am talking to you, you all some 35 years later. I guess I just got caught up. So I practiced law for 9 years at a large law firm, a national law firm headquartered in Minnesota, where I was one of only 3 or 4 lawyers of color there for most of the time I was there. And it would be just successive generations of lawyers of color that would come and go. I was the first lawyer in the firm who had actually lasted there more than 2 years in its 50-year history when I joined the firm. And I owe that to what I call my North Carolina roots, and growing up from folks who just worked hard, and the fact that things are difficult, well, you just keep working hard and leaning in. And I felt that my trajectory probably wouldn't be different than others who had come before me. So I really put the onus on myself to try to achieve by the time I was in the first year what third years are doing, and by the second year what fourth years are doing, and so on. And I got better more quickly than some of my peers at the sort of the art of advocacy. And before you know it, I had made a partner at the firm. My practice was then and is now, has always been civil practice. I'd never been a criminal practitioner until the prosecution of Derek Chauvin, where you saw me playing a criminal lawyer on TV. And I would say because that was the first criminal case. Prior to that time, I've been involved in, you name it, for civil litigation, from complex environmental matters to multi-district litigation, class actions, intellectual property disputes of various kinds. For 4 to 5 years, I was the lawyer for Prince, as in, hello, Mr. Blackwell, this is Prince. I was Prince's lawyer for several years too, as outside general counsel, and through it all, a trial lawyer. So in being a go-to trial counsel for various Fortune 500 companies, it's a practice that I sometimes refer to as smoke jumping, because I'm not the lawyer who necessarily did the workup of the case. And I will quite often be called in after discovery has been done in the case. So I'll come up with very, in my mind, brilliant approaches to how we might be able to defend this or prosecute it, and then find out, nope, there's no there on the evidence for that. We didn't develop that. And that's been all over the country for what I call the smoke jumping, from Honolulu to different parts of Mississippi, to down in the valley in Texas, to Sitka, Alaska, to Maine, to South Carolina, to you name it. I mean, I've been kind of all over as a national trial counsel. And I do believe that maybe this will get more into the interview questions at some point as to why the Attorney General would have called me with no criminal law experience in a case like this, which I was so honored to do. So that's a bit about my background. It has been all civil litigation. It's been all kinds of civil litigation kind of over the years, at least the way I was always taught, even going back to law school, then at Chapel Hill, that other institution that you all have heard of at Duke, that even in Chapel Hill was, if you are a trial lawyer, you can try any kind of case. And that I believe that if given the right kind of support, then every case involves its own learning for the law that's going to apply, even nuances in the law. There's usually a technical thing to master in the case, be it how a product performs, or processes and procedures for the police, or what have you. And a jury's a jury. There's no such thing in my mind as a criminal jury, that antitrust jury, or this or that. It's just a group of people who are trying to decide what happened. And I find that the approach that I took as a trial lawyer was the same, whether it was a criminal case or whether it was a complex civil litigation. So those are my sort of preliminary remarks. The kind of most out there representation I've ever had did involve representing press, no question about that. And that was real challenging. I used to keep this ring on right here, this one. I called it my decoder ring. And that way I could listen to what Prince might ask me to do. And then I would look to the decoder ring to translate that into what's really going to make sense to try to do in this instance. And so that was out there. I had never set out to be an entertainment lawyer for what it is worth. And again, it was just something that I fell into from initially defending him in litigation in Los Angeles. And then there came a time when he no longer had counsel. Well, he no longer had him because he fired all of them. So then he found himself in need of counsel. He says, hey, how about that black belt guy? And with that, I became his lawyer for all purposes for several years. So with that, I'll stop and maybe we can engage in more of a discussion. But good afternoon, good evening.
Thank you so much for being with us. And as a huge Prince fan, I'm tempted to go off script and to ask you a series of questions about that representation, including, did they ever find a will? Right?
Ask me no questions, I tell you no lies.
Okay, all right, then I'll go back to the topic at hand. And we will get to that question about the Chauvin trial. But before we do so, based from your introduction and from Professor Haney's comments, it's clear that you've handled a diversity of different types of cases, from representing Fortune 500 companies to representing Max Mason, for whom you obtained a posthumous pardon. And for the participants, Max Mason was a Black circus worker who was wrongly convicted of rape in 1920. An angry mob lynched 3 other Black men who were arrested with Mason. You also founded the Minnesota Association of Black Lawyers, which aims to promote the professional development of Black law students, lawyers, and judges. Given this diversity of experiences, could you tell us how race has influenced your approach to your professional career, and perhaps what you perceive the role of Black lawyers to be?
That's a really big question. You know, as Nelson Mandela said once, where you stand in the world depends on where you've been sitting. And so when I think about how has race or Blackness affected either my approach to the law, my trajectory in the law, my reactions in the law, it's simply ingrained into my fabric. I stand in the world kind of where I've been sitting, and I've been quintessentially African-American, in fact, quintessentially the African-American experience. And so when I go into a large law firm, I absolutely hope for the best. But at the same time, I'm realistic. I mean, I'm aware of the fact that the attrition rate for Black lawyers is 100% every 2 years. I'm also aware of the fact that that's not a fact I'm supposed to publicize, right? It's not the sort of thing that you show up and say, hey, excuse me, I have a question for the partnership. And that you experience that kind of two-ness, the TWO-ness of on the one hand saying we are committed to broad and noble kinds of things for our creeds and our core values, but at the same time it's inescapable, as to me, kind of how we're doing in realizing them and what the accountability is around. And then you understand sometimes, as the person of color in the room, that you have realities or truths that you can't always give voice to, and at least to not expect to sort of advance for not being viewed as the person who's now creating a problem by just bringing it up. So that to me has always been a part of of my experience. That I certainly have had the experience of having to what I'd call run faster, run harder, jump higher, just to get ahead. And I always say it'd be a damn shame if I couldn't do those things, right? Because you're going to have to. There's nobody's coming for you. And to get in and then to play. I am always, what sustains me always is first knowledge of the history, for one. And that's the broader history of African Americans. in the country. My great grandfather on one side was born in slavery in the country still. So that's how far removed or not it is for me. So the history in a broader sense sustains me, and knowing how hard my parents had to work, whether it's my father with a 10th grade education driving a truck long haul, or my mother who worked in the textile mill in a textile mill town. And then I think whatever may be my difficulties, they pale in comparison. My third year in law school, I really had the honor of working on a hobby farm of Professor Harry Groves, who taught at the law school. And if you bring to mind James Earl Jones and that kind of sternness and so on, he had both the look and the voice of that, of James Earl Jones. And on Saturdays, he would always be working out there on the farm. And I never forget the Saturday, he was there with his good friend, John Hope Franklin. They were very good friends. And they liked to raise orchids. And this to me was a whole new world. I'd never seen African-American men that raise orchids. So I just got to stare at them, so let me just see if I think they're even legitimate. And so I got out to spend time with them, and Mr. Groves talked about coming back from World War II and having served the country there, but then being made to sit on the train back behind the German POWs on the train. And he and Dr. Franklin engaged in a discussion around that I was just blessed to listen in on. And it gave me strength, really, because whatever might be my challenges and issues, I think about how they achieved in a different time with hurdles that were even higher and carried weights that are even heavier. And so whatever might be my challenges, I figure I'll never use that as an excuse to not keep on keeping on. And so it for me, it informs the drive I have. It informs the passion I have for justice. And I knew too many people coming up who didn't have college degrees, who didn't have letters, and who didn't have the opportunities that I had, that I would see in church on Sunday morning, who would press a little piece of money into your hand to say, you do good in school. I represent all those people. And so when I stand up, that's the community to me. And so when I see what happened to George Floyd, when I see what happened in the case of Max Mason, a young man who was wrongly convicted of this fictitious rape 100 years ago, and to me, it's standing up to do my part as a member of the community to try to advance the ball just a little bit without any real concern for how I get paid back or anything else. I've been paid plenty forward. But it inspires me to stand up for, to me, a greater justice. And that is informed by having grown up in this country as a Black young man, now a Black older man, and having those truths that I know to be truths that are true for me and people like me.
May I ask a follow-up, Professor?
Okay, all right.
So I understand what you're saying about history sustaining you. Sometimes when I'm in conversation with students of color, particularly students of color in the law school, they think that going to a corporate law firm and representing big corporations is not consistent, right, with a commitment to social justice. Could you speak to those students about your experience with a law firm that represents major corporations and how you feel that work can actually contribute towards social justice?
We both belong and have a right to play in every societal sphere that's worthwhile, including those that involve representing and defending the biggest, most moneyed interest in the country. We have the right to be able to play there too. And when you look at, for example, it feels almost like a renaissance that's happened in corporate America since the death of George Floyd, with their commitments and coming out now to justice, to equity, to paying attention to where the spin goes, all of which is inspired there. If you're not in that game, if you don't have people of color in that game, in a position to bring about the critical decisions to take action, then for me, it's a missed opportunity to be able to do what you can from the inside to be able to advance a ball. And I always say that when it comes to issues of fairness, of inclusion, it isn't just about protesting on the outside. You need folks who are on the inside too, who are strategically located, who are not just there for head count, but who are empowered inside there to be able to bring about change. And again, it's all rooted in the fact that culturally, you may have a different experience than your white colleagues. It's not about right or wrong. It's just the world that you come up in. You have a different perspective on it. That perspective matters. And it is much easier to effectuate change in such an institutional way if you are on the inside and you have control to the levers and mechanisms that effectuate change, than being outside with a picket sign saying what you want to do inside the company. You instead can be in the company and point to what I am doing inside the company. And so I never considered, there's nothing wrong, don't get me wrong, with being out in the public sector and doing these sorts of things. But I figure we need representation in all of the critical boxes, in my view. And so that to me means the ballot box, the jury box. Boy, there must be, I had like 2 other boxes, but all the sectors and spheres that impact our lives, including corporate America, we need to be represented there. So in fact, I started this law firm, Blackwell Burke, after being a partner in a large law firm, because I did not know of another firm in the country I was aware of where you could be an African-American person. No, you could come into that law firm and then represent the largest companies in complex litigation without feeling that you're having a battle against diversity issues. And then be perpetually assigned to diversity committees where quite often you're discussing the same things, the same issues with the same people every year, but you're not supposed to say that. And let alone point out that we haven't had much progress other than simply giving ourselves awards for having these meetings. But the numbers don't appear to have changed any. And so this was an alternative. It was a way of trying to do my part to actually try to create an example, a model where things can work. Rather than putting the energies just in the perpetual diversity, equity, inclusion committees, which are fine. Don't get me wrong, but this was an alternative that here I can start something else that's institutional, and why not try to do that instead? And that's what I did in starting Blackwell Burke.
Thank you so much, Mr. Blackwell, for joining us. We're just so excited to have you. I want to pick up on just a couple of points that you made. When you joined the prosecution in the Derek Chauvin case on a pro bono basis, this meant you would not get paid, right?
It didn't.
You did not get paid. What led you to this decision, particularly given the fact that you didn't have any experience as either a prosecutor or as a defense attorney? And then how did your prior experience prepare you for this powerful case?
One of the things that was unique about George Floyd's death, about the murder, is that George Floyd died in all of our living rooms. I mean, we all saw it, experienced it. I could personally relate to it. I'd never been, beaten by the police, but I have been stopped for no reason repeatedly by the police. I have been followed around as a person who fits the description of, even though I don't, by the police. I'd had some of my own experience about feeling singled out, put up on, oppressed, if you will, by the misuse of authority by a person wearing the badge who should represent the people and should be protecting and serving the people. But instead, I feel myself being the object of a kind of abuse of that authority and power. And I think many people could identify with that kind of treatment. When I saw what happened to George Floyd, I had just a reaction that was like a fire that was, as they say, shut up in my bones, to want to do something. What I can do, I don't know. I'm a trial lawyer. It's a criminal matter. I don't know how I can help, but in my heart, I just resigned myself. Anything I can do, I'm going to try to do. And I kid you not that it was completely happenstance that I hadn't contacted the Attorney General, but I had sort of developed this fire in my belly. And then the next week I got a call from the Attorney General, just out of the blue, asking, would you help with the prosecution of this case? And as a special counsel, I'm a special prosecutor. And you know, what would make it special, I knew, not only will you be outside the office of the Attorney General, but you'll also be special because you will not be paid for this service. And for me, I said yes immediately, right away, count me in. And I had not even spoken to my wife about it. I had not spoken to my partners about it. You know, I describe it as almost a certain kind of a hidden wiring in your DNA, so to speak, that when the right circumstances present themselves, you just sort of get activated and start marching north. That this is, for a moment such as this is it. This is just as compelling for me that I jumped from the diving board on this one and then check for water second, that count me in. I didn't expect to be on a jury facing role on the front line of this trial. I thought that this were a college drama or a play. I thought I'd be back behind the stage, helping with costumes and hemming the curtains. That I had expected to help on crafting the narrative, on working with the themes, and helping the other criminal lawyers kind of get ready for the trial. It was, though, in the process of working on the various themes for the trial and crafting the narratives, that I kept going, no, that's not quite the new, no, not that way. You present it this way. And by the time it was finished, they thought, well, all right, well, you do it. I thought, well, fine. Well, I will. And that really was more or less the process where I ended up, you know, being in a lead counsel role. I did have a fairly frank discussion with the Attorney General when he asked me to take a lead role in the case, because I thought it was a tremendous risk to him. It was an obvious personal risk to me because you may not know this, some of you, but the number of lawyers in the country that represent a Fortune 500 company as national trial counsel, I mean, lawyers of color, Black lawyers in particular, are slim to none. I mean, if there are 4 others, I would like to meet them. Because even today, it's something you hardly ever see. So, and for me to have been a national trial counsel for some of these large, you know, companies meant there was a lot at risk, because I could get involved in a case in an area that I don't even know and lose all credibility. And once you have, they're not going to have you represent them anymore. I could have ended up as a joke on a T-shirt or a meme. So I told the Attorney General, you know, I'm fine to do this, you know, but if it goes south, you don't need to worry about me. I'll be vaporized, poof, gone, done. I said, but you will still be around for the political attacks, and there's nobody who's not going to criticize you for having put a non-criminal lawyer into a lead role in this, and that's a big risk, you know, for the Attorney General. You sure you want to do that? He said, hey, I'm putting in, he said, the best at each position. You're in. I said, all right, then I'm in. And it didn't seem right for me to start thinking about how to be paid and doing it. It was so much bigger than that to me. It was, I mean, the trial represented so many things to so many different people. For some, it was a referendum of sorts. It sort of raised the question that if there can't be justice brought about in a case like this one, that's this blatant, that is this bad, that is this brazen, is Dred Scott true? Is it true that Blacks have no rights that whites are bound to respect? Is that true if there can't be justice brought about in this case? I'd like to believe that the system can be made to work, and I want to commit to getting it to work in this instance. But many were watching it, not just here in Minnesota. As you know, you certainly watched it in North Carolina, but I heard from people from China to Sweden to Peru to you name it, who are watching this trial every day. And and certainly all over the continent of Africa. I've had some of the most interesting discussions with translators from countries in French-speaking West Africa on the trial. So, this was kind of how I came to get involved in trial, what I thought my role was going to be in it at the outset. When I agreed to participate in the trial, there were no cameras in the courtroom at that time. There had been no decision made to have cameras in the courtroom. And so as the case and the facts evolved, and the Attorney General says, well, I want you to take a lead role. I said, oh, okay, all right. And then we learned that there'd be cameras in the courtroom. I went, oh, cameras, oh no. Because the trial lawyers like to say, we can try anything. We can try any kind of case. You don't expect to be put to it with cameras on an international stage though. Well, that kind of upped the ante. And then we learned later on that there might be some issues of drug addiction in the case. I said, did you say drug addiction? I said, oh, okay, no worries. So I didn't know ultimately whether this was a calling from the Lord or whether this was payback of karma I owed in getting involved in this. But either way, I figured I'm in to verdict, and we'll give it my best.
I think I read somewhere that you, and I'm paraphrasing, described this as a moral imperative, perhaps, participating in this prosecution. From an insider's perspective, what was the biggest challenge facing the prosecution?
Well, there were a few what I call sort of biggest challenges in the case. Obviously, the history. Number one, the historically, the challenge of trying to convict a police officer in an excessive use of force case where the victim is African American is a rare thing in America still. So we knew we're up against that. That's in part because amongst much of the population, there is such a high regard and respect and trust in the police and in policing. And so many citizens just do not want to believe that that police officers would ever do that. And they'd much rather believe that there was something confusing in the situation, that there need to be a snap decision, a split-second decision made, that given time for reflection, they would have decided differently, but you don't criminalize them for having made the wrong call in a split second. So we knew we were up against that. There were drugs. There were drug issues in the case, which was, again, huge. If it takes one juror to raise and hold on to the notion of reasonable doubt for us to have lost, and were they to decide that George Floyd did not die as a result of subdual and the restraint, he died because of his history of drug addiction and the comorbidities in his system, whether it's high blood pressure or narrowing of the arteries, et cetera, that was, in fact, the overarching cause of his death. And that's a challenge that we have to unravel that. And then there are always what I call the undercurrents of the case. These are the kind of currents that don't appear in the formal language of the jury instructions. That's what I call the referendum issues. Is it a referendum on all policing? Is the case a referendum on race? The whole drug issue, is that really just a proxy for issues of race in the case? That to the extent the jury is hearing about pills that George Floyd never took, we know what level of fentanyl or methamphetamine were in his system because we have his toxicology, his tox from the blood workup. So then what's the relevance of pills he never took as to his behavior? Well, there's always the risk that some jurors would hear that as drug equals thug. And thug is not somebody for whom we're going to convict a white police officer just trying to do his job. So there were race undercurrents that we had to get at. And some of the ways that you saw us getting at some of this stuff that may be just below the surface here is that we didn't make the case a referendum on policing, that we made the case a referendum on the behavior of Officer Derek Chauvin, not all police. And as well, we went out of the way put a great deal of energy and effort into humanizing the humans in the trial. You actually met the bystanders. You got to know the bystanders. You could not describe them as just an unruly mob, which they were characterized as an unruly mob, but then you met them. And you found them to be, to the last person, very concerned citizens, models of good Samaritans, those who are going out of the way to try to make a way for somebody that didn't even know and putting themselves at risk to do it, who had far greater civility, humanity, dedication to serving a member of the public than did the officers who were making the improper arrest. But that was important to overcome some of the undercurrents that may exist in the bellies of some of these jurors. We humanized drug addiction, which was very important in the case too. So what was the biggest challenge? All of those to me in a gestalt were the biggest challenge in the case that I felt we've got to have a response for all of those things.
Professor Lovelace and I both have a question, a follow-up question, so I was deferring to him. So could you just take us into the lawyer deliberation process? So you know that there are going to be these challenges, right? Public trust in policing, right? Drugs, right? The racial and all the other undercurrents, right? So you identify these as potential challenges. And you said earlier that part of your role, right, what you brought to the table was crafting this narrative, right, from your experience as a trial lawyer. Could you just give us a brief glimpse of what those conversations were like?
Oh, they were spirited.
Lawyers?
No, they were spirited discussions that got had within the team. But the hats off and credit to the Minnesota Attorney General for bringing together a group of both special prosecutors and career prosecutors this way. Because a number of us were what I call sort of the civilians out here. And I'm there to ask all the why do you do it that way questions. And from the most fundamental things to criminal lawyers, Brady Giglio, where I start with, you're going to disclose what? And you're going to disclose that why? So starting with those kinds of questions, to having a real sensitivity about undercurrents of race that to me just are transcendent just in the body politic of the country, just with any sort of group. And we can't afford to sort of be naive and to simply think if they're given a jury instruction that will bring about itself a fairness. And I said, because it's an emotional, it's an intuitive reaction that persons have. So there were times, even within the prosecution team, which I got along, great with this team, and we'd have rock'em sock'em, arguments sometimes where it was like mixing oil, water, and a brick at times. We've been arguing over some of these issues, and I was would be certainly attuned to things that struck me as dog whistling. As an African American, I would hear it. And then we go, wait a minute, that dog whistling isn't for me. It's for other jurors who would pick up on this. And essentially asking the question, are we really going to throw away the life of this dedicated public servant who happens to be white for that? And what is described as a that would be George Floyd. He's big. He's menacing, he's drug crazed. Even when he doesn't have a pulse, we're afraid that he may revive, come back to life, break the handcuffs, and rampage the city. What could be more tropish, in my view, than that image? And I think that image was one that was, in my view, was projected. I heard it. And we got to be prepared to respond to that. So I felt it was kind of my role on the team to not only keep focused on what we have to prove per the jury instructions, but just as a trial lawyer, understanding that people do not make decisions first and foremost on the analytical, intellectual basis for most people. Decisions are made from the belly, emotional, moral, what is the compelling force of the narrative that you are telling. Thereafter, now, show me the law so I can see how I'm going to use them to do what I want to do. And so it's getting to what do the jurors want to do? That's the compelling narrative. So so on that team, I'm thinking about, other than the Attorney General, I was the other African-American lawyer on the team, and I had my own sort of personal experiences. And there were times where the team thought maybe, you have lived so closely this experience, have you lost objectivity, right? So we'd have those kinds of questions. To which I'd say, I would expect you to ask that kind of question because you have never had objectivity. And, so there would be good outcomes. You saw it in the trial. You saw it was presented in the trial itself that grew out of those discussions. We put on a case that did not follow the ordinary playbook for how a prosecution would approach a case like this. Or so we were told by a number of the experts who called in and commented on it. And to which they said, that's not how we would typically do it. And I can say, well, I didn't know that, right? Because not bound by that. We in the trial put infinitely more energy on issues of medical causation. And you could probably see in the trial that I focused particularly on the medical causation issues in the case. I had, whether it's putting on the Dr. Tobin, who was the pulmonologist and respiratory specialist, who was put on, or cross-examining Dr. Fowler. And that was more down my bailiwick from the civil litigation that I do, and was more in depth than the typical prosecutor would do. So many prosecutors for the medical case are accustomed to simply putting the medical examiner on the stand and pushing essentially the play button. And I felt that in this case wouldn't do. So we had a number of medical experts that you saw. So that's a little bit of the coloring and the flavoring in the trial. I have to say this, and I can't say enough how critically important I think it was to have had an Attorney General who had the courage of Attorney General Keith Ellison to pursue this case in this way and bring in this group of special prosecutors. And that took a lot of courage. It also took a lot of courage from the chief of police here, Madera Arredondo, who's the first African-American police chief in the history of the city of Minneapolis. And so Keith Ellison is the first African-American Attorney General. And it is Chief Arredondo's leadership that led to so many of those officers stepping across the blue line to call out bad policing, as in the best interest of good policing, and to have them testify. But it was Chief Arredondo's leadership. And it's not often, at least not here, that there is a lead prosecutor who's African-American too, which I was in the case. So to me, those three things matter just from a perspective coloring point of view, that in terms of how the world was seen and the space out of which each of us acted in the case. Now, none of that matters, right, unless you have the right jury. So as the saying goes, you can have any facts you want if I can have any jury I want. So we had a phenomenal diverse jury here too, that heard the evidence, and I thought were attentive the entire time, and came to the right decision, and didn't take too much time arriving at it either. They came in much earlier than I thought they would.
Mr. Blackwell, you were heavily concerned with medical causation and humanizing Mr. Floyd. In the closing portion of the trial, you made a really powerful argument. I think it's one of the arguments that's going to stand the test of time. Essentially, you argued that Mr. Floyd had died. Well, the defense had argued that Mr. Floyd had died because his heart was too big. But for you, the truth of the matter was that Mr. Floyd had died because Mr. Chauvin's heart was too small. When I heard that, I mean, this was such a moving response, a memorable response. Where does that come from? That sort of that rhetoric in a way that you just humanized him as a litigator. What's your inspiration? Because that's such a powerful argument.
It comes from North Carolina and Kannapolis. Really, because there you get used to speaking in metaphors all the time. And even for me as a trial lawyer, quite often my responses to a lot of things first come in pictures, then I have to translate it to words, but it's the picture I see first. And this was just a picture that I saw when he kept talking about his heart being too big and this and other things that to me were just made up. I mean, that carbon monoxide argument in the trial, it just didn't make any sense to me at all. But when they kept emphasizing how large his heart was, and in my mind, I thought here was a little girl who then was 8 years old with the word love written on her t-shirt, who was there at the scene. And even she understood. This was so simple, a child could understand what needed to happen when she just said, get off of him. That's how simple it is. And had he the caring of a little girl and her tiny little heart, this would not have happened. And that to me, contrasting the defense arguments about the enlarged heart of George Floyd to the tiny heart from a human point of view of Mr. Chauvin, encapsulated both the excessive use of force issues and the medical causation issues in just one little phrase, that the size of her had nothing to do with why George Floyd is dead, but the size of Mr. Chauvin's had everything to do with it, why George Floyd was dead. And so when I thought of that, I thought that is what I'm going to end on with the rebuttal. If you had been in the courtroom, you might recall the closing argument for the defense went on for hours. And the poor jury looked like a wilted plant that somebody had turned up the heat and it's just flopped over in the chair that had been talked. So I figured the rebuttal, I couldn't go on for too long because the jury was certainly ready to get on with the deliberations. So I wanted to pick out just a few things that were notable about the defense closing, just to take some rifle shots at it that were meant to be sort of representative, but then to close it out on what is this really all about. It's about the fact that these are public servants who took a sworn oath to care. You know, that caring for the public is viewed as a sacred duty, the sanctity of life viewed as sacred. And that's what that badge represents, you know, that you undertake an oath to care. And here it was obvious that they didn't care. They weren't there to serve the public. They were there to dictate to the public. And with the sunglasses up on top of his head, the look of scorn on his face, contempt, all of it spoke to what the intentions were, what the attitude was, what the mindset was, that even after he doesn't have a pulse, you stay on him for 4 more minutes and the paramedics show up and have to touch you to get you off of him. I mean, my Lord. So it may be that the most remarkable thing here is that why should a verdict in this case have really been in question, given the force and strength of the evidence? But I can tell you that according to the polls I saw, that only 42% of African Americans thought there would be a conviction, even in the face of the strength of that evidence, given the history. And I had colleagues who are white who would say, but it's right on video. How hard can it be? I said, well, did you not see the Rodney King video that we all saw where there's an acquittal? I said, and for that matter, the lynching in Duluth, where we obtained the posthumous pardon 100 years later, there were 10,000 citizens there in a town of 100,000, 10,000 white citizens there as participants and witnesses to this lynching of 3 innocent young Black men. And they were so satisfied with their handiwork that they took photographs of themselves to turn into postcards. There were judges amongst the 10,000. There were lawyers there, prosecutors there, members of the National Guard in the audience. Nobody was tried and convicted for murdering those 3 young men, and everybody saw it. They all knew who they were. So when it comes to me, issues of fairness and justice, the rule of law and all the rest of it, the fact that everybody has seen it itself is not any guarantee that you're going to get anything that looks like a just result. And that is why I think the majority of African Americans were still sitting on the edge of their seat. And me too. You know, I was hopeful, but I mean, I sat there too for 1 hour waiting for the jury to come in, which is the most defenseless period of time in the life of any lawyers when you're waiting for the jury to come in, because then there's nothing you can do. They have all of the power, all the control. All you can do is wait to hear and hope that you did enough.
Do you consider the verdict a vindication of the criminal justice system?
Well, I consider the verdict to bring about accountability for Mr. Chauvin. Yeah, I don't really even necessarily call that justice, because as the Attorney General has says, if it were justice, George Floyd would still be alive, but it was accountability. I think that the criminal justice system, in my mind, can never be any better than the men and the women who are the stakeholders in that system. That we both are the creators of its content, and collectively in what we do with it, we create its character. And we, no doubt, in this country still have a mass incarceration system as relates to brown and black people. It's widely kind of recognized that this occurs. And that's still occurring even in the wake of the verdict for Derek Chauvin. So I don't think that when it comes to any issue of a racial fairness or justice that's historic in nature, there are no silver bullets. There is no such thing as a single event ever that is the thing that makes the criminal justice system fair, the thing that means that now we are post-racial, or any of the rest of it. But all those things matter, in my view, to what I call flipping the brick of justice and fairness, and not the wheel, because this never rolls on some smooth pavement of inevitability, and it just sort of creams forward like a wheel. I mean, justice moves like a brick, and the terrain is rough, is full of potholes, inexplicable switchbacks, and it takes a great deal of effort to flip that brick each time in a forward moving direction. So this to me was a flipping of that brick. It was a good flip, but it doesn't in and of itself mean or represent reform. When I was after the verdict, I was in the hallway standing next to Attorney General Ellison, and he handed the phone saying, "Somebody wants to talk to you." So I take the phone and, hello, this is Vice President Kamala Harris. And I thought, wow, I didn't know what she said for the next 7 seconds, because I was just like tripping. This is Kamala Harris. And so when I came back around and listened, she was excited about the verdict, and felt that it represented a kind of inflection point in the country on issues of racial fairness, and certainly in the criminal justice system. And that's a perspective. I don't know that the history supports there being inflection points of that sort. If so, we've had a lot of inflection points. From the end of the Civil War was an inflection point, and the 13th Amendment was an inflection point, and the end of Jim Crow was an inflection point, and Thurgood Marshall's appointment to the Supreme Court was an inflection point, and certainly the Voting Rights Act and the Civil Rights Acts were inflection points. President Barack Obama's ascendancy to the presidency was an inflection point. And I just feel we've been inflected so much as a wonder we can walk with the inflection points. So all those things matter, so don't get me wrong, but the notion that there's any one thing that signals that the path going forward on these issues will be simpler and easier and smoother than the trajectory of getting to this point. To me, I wished it were so, but I think it may not be so. And I think we just have to keep making the efforts.
And certainly that brings to mind the aftermath of Breonna Taylor's murder. And the day after the George Floyd verdict was announced, there was the killing of a person, Mr. Brown, in Elizabeth City, North Carolina, right? And so you have these ongoing questions that even after that particular moment continue to arise. I think Professor Lovelace is going to ask a question about reforms.
Yeah, so Mr. Blackwell, you talked a little bit about reforms. what sorts of reforms do you think are necessary and are being considered in Minnesota specifically to create more racial justice in policing and in law enforcement?
Yeah, and I would say that this is an area where my opinions don't really carry any more force than anybody else's in this regard, because I do sort of recognize a line where uh, this is sort of not my day-to-day kind of work, but I was a criminal prosecutor in the case, and I have thought about it, but so have lots of other people. But one of the things that I know that the Attorney General has been advocating is number one, to support at least the creation of a registry so that we know exactly how many people and what the demographics are of those who are being killed in custody, police custody cases, that we actually track it so that we're aware and can see the trend lines from one year to the next. The idea that if there's been a police officer who has engaged in various types of excessive force, that in a registry should record the name of this police officer and the offense, so that he or she can't simply go to another police department and pick up without any accountability or even any sort of historical trails for what's happened. Those are the major two that I've heard our Attorney General here talk about, Tim.
Tim, do you want to switch gears to judicial appointments?
Yeah, we can. So in terms of the judiciary, well, first, you served on the Minnesota Commission on Judicial Appointments. The judiciary is historically and notoriously non-diverse, and this is true particularly when it comes to Black judges. The Biden administration has committed itself to addressing this issue, at least on the federal level. Drawing from your experiences, can you comment on the significance of racial diversity in the judiciary in the future?
I think it's to me very important, extremely important, not only to representative government, a government that should represent us all, that justice, in my view, should not only be just, it should also appear to be just. And if you appear in court all of the time as a black or brown or any citizen, and the judges are simply of either all one race or all one gender, then that doesn't even appear to be just. And as it turns out, I mean, judges are not what I would call sort of protoplasmic Autobots who simply objectively apply legal principles to the lives of individuals and bring about a single inevitable ruling. The judges are people too, that they are to bring their life experiences to bear in how they make judgments, and it has to do with the sensitivities you have, or what do they even see. If you are a judge who has never had occasion to have been stopped by the police for no reason, do you even stop to question the statements that may be made by police officers in what may be a pretext stop scenario? Do you even question it when that's not part of your experience? And I do think that bringing together the greater mosaic of the people can only bring about better judging, to have those different perspectives on the bench. Even Justice Scalia at some point had to comment on what a difference it made to have Justice Thurgood Marshall on the bench for the way that he had challenged them based on his life experiences, based on what he had seen on issues of racial justice that came before the Supreme Court. It may not have reflected in their jurisprudence necessarily, but he did say that they sat up and took note in a different way when Thurgood was in the room, because he quickened the sensitivities around the issues, and which to me is important. That judging is interactive. The judges talk to one another. They bounce ideas off of each other. And having those different perspectives, they're critically important. I mean, no single one of us can ever be smarter than a collective, all of us. And having diversity of perspectives brings about to me a better, more complete, broader kind of a justice that's based on a broader spectrum of the human experience. So very important is what I think it is, Tim.
Thank you so much. It looks like we have a robust queue for Q&A. So before we ask our last question, Professor Lovelace, I'm going to combine the final questions into one, if that's okay with you. Let me just say thank you so much for your work in the Chauvin trial, because, you know, even with a videotape, with international and domestic protests all over the country and all over the world, with police officers willing to testify, with an attorney general willing to prosecute, it was still an uphill challenge, right? And many of us were sitting, you know, waiting with our hands shaking for that verdict. So thank you so much for what you did in terms of shaping the narrative, the medical testimony, and humanizing Mr. Floyd, as well as bringing in witnesses, right? And humanizing those individuals who undertook the challenge of describing what they witnessed. So our final question, would you like to take this on, Professor Lovelace, or shall I proceed?
Sure. Students, right? So we have many students here on this call. What advice would you give to a student who's interested in the role of lawyers in securing racial justice?
Well, a broad question, you know, my first response for every student is, first and foremost, be the absolute best student you can. It is the first best thing, because I can tell you who will be the MVP of any Super Bowl. It will be somebody who's in the game. And if you're not in the game, because you're not even on the team, then it's probably not a question you should be asking, right? Because you're not going to be playing. So the first thing is to put the energies into being the absolute best student. And if you're going to, once you finally get in the game as a lawyer, to first and foremost, focus on being an outstanding lawyer. Learn the art of advocacy first and foremost, because that will be your ticket to being able to have influence in so many other areas. Is first standing on the foundation of and having a reputation for being a very good lawyer. And that'll get you into certain rooms to have certain discussions that you otherwise are not in. So that's the first thing. And the second thing is to never, ever forget kind of where you've come from is the second. You don't have to do necessarily monumental great things. You don't have to mount the next civil rights movement. You just have to do the little things that you can do right where you are, whether it is kind of making a way for others to get in the door, kind of where it is that you happen to work. It may be that for those who are in the door, you school them so that they realize kind of how to succeed. And certainly if you go into any kind of corporate institutional type of firm, the rules for success are not necessarily televised. And so you have got to learn, you know, kind of how the place operates, and how is the power distributed, how decisions really get made, et cetera. So for students interested in being a lawyer and securing, to me, racial justice, you can do that wherever you happen to be planted. And you should make it a point of doing that wherever you plant it, whether you are a public defender, a prosecutor, whether you work in a large law firm, whether you're in a corporate law department, whether you're in academia, and in this country still, at any intersection, at any place where there's a confluence of money, power, resource allocation, opportunities, you'll almost always find disparities in every single one of them. And not just in 2021 or 2022, it's been that way forever, always. And so wherever you are planted, there are things that you can do, even in little ways, that will make a difference. And for some of the bigger things that you might want to do, I could not have taken on Derek Chauvin trial as a second-year lawyer, I'm pretty sure my law firm would have rolled me out of the door like a bowling ball if I had just decided that I'm going to take a year where they're going to pay me, and here's what I'm going to do. The Attorney General would not have asked me to do it, for one thing. The law firm probably would not have supported it. So I'm saying that you also have to learn to bide your time and to be patient, to do the things that you can do that makes sense for today, but play for a bigger game tomorrow, because guess what? The likelihood is you will be around tomorrow. And you know, learn and save your thunder for some of the things that matter, and bide your time. For the day that you can play and make an even bigger impact. But the root to all of this, in my mind, is first and foremost having a heart, you know, that cares, that matters, that's compassionate, that doesn't forget. But then with the mind, putting it to work to being the absolute best you can be at what you do. And you understand that you have to do what you do quite often when you are kind of by yourself, when others of your friends want to go hang out. That solitude is the price you have to pay to be great at anything. You have to be willing to do it when you're kind of off on your own by yourself, when there are things you'd rather do. And if you didn't have to do that, everybody would be great, you know, but everybody's not. So you have to be willing to pay that price of what I call the solitude, to be clear about what you're about, and whatever you do. If you want to play a role in securing racial justice, do not make your pursuit of the law purely about making money. You know, please do not. Find something that really matters to you, that really calls to your heart. Dedicate yourself to that. Dedicate yourself to being the best at it, and the money will follow. Let it follow that. But let the calling be first and foremost about something other than making money. That's fundamentally about service, and then let the money follow. So that would be the advice I would give.
Thank you so much. So we're going to turn this to Professor Haney for questions from the queue, and it looks like there are quite a few questions. So I think we've saved about 30 minutes for Q&A.
Yes, thank you, Professors Jones and Lovelace, and my good friend Jerry, for a wonderful conversation. And I've been collecting questions as we've gone along. So here's the first question to you, Jerry. Why do you think you and the team were successful in this case when there's so many other cases of murder of unarmed Black men that were not successful? And follow-up to that is there a strategy coming out of this trial that can be used to prosecute other such cases?
You know, this is sort of my best speculation as to why that is. You know, Attorney Ben Crump was at the trial for a good part of the time, and he's been at virtually every other trial, at least in the last 10 years, involving death in police custody. And he said that this was the most robust prosecution he'd ever seen in a case of this sort. And I think a part of what made a difference was the fact that the Attorney General here brought in special prosecutors. I mean, he went over to civil practitioners and brought us in. And we brought a certain sort of method to how you work up a case, and it worked it up like we do a complex case with the processes and the various checklists, which I won't go into. But even beyond that, the emphasis that we placed on not doing things the way you always do them. In the typical, for example, criminal prosecution, they would call the spark of life witness first, I'm told. The spark of life witness is the one who talks about the personal aspects of the victim, who he was, how he lived, et cetera. Spark of life witness, they usually call first. We call that witness last. And that was because George Floyd, in my view, wasn't on trial. So why am I going to start off the trial talking about him? I want to talk about the 929 right from the start, because that's what's on trial. That's what Mr. Chauvin did in the 9 minutes and 29 seconds on the ground. So that part was very different. The whole medical case was different. You know, Barry Scheck, who's now with the Innocence Project, but was a science counsel in the O.J. Simpson trial, followed this very closely and said, we are taking notes, because we took a different approach to the medical case and causation. We layered experts from the cardiologist to the pulmonologist to the emergency ER physicians, you name it, because we wanted the jurors to really understand the science and the medicine, to understand the toxicology, such that it would not be easy to get up and just bamboozle on the medicine and point the fentanyl and say that this was part of the reason he might have died, driving reasonable doubt in medical causation. We put on a different type of medical case. My hope is coming out of this, and if I ever get enough blue sky to work on it the way I would like to, is to try to bring together and to create an organization where there can be other partnerships between the private practitioners and the public sector, prosecutors, in cases of this sort, to be able to bring these kind of resources to bear. We had experts who volunteered their time in this. People like the Dr. Tobin, the pulmonologist who testified also free of charge. There are others who contacted me who looked to be fantastic experts. We had enough. And who would like to be able to serve, I'm sure, in other cases of this sort. And typically you don't have that in cases of this sort. We had an attorney general who was willing to charge the case out properly. And it's not a comfortable thing, even for career prosecutors, I think, when somebody sues the police, when the prosecutors are used to working closely with the police or used to working closely with the medical examiners. Now here comes a lawsuit that completely busts up those relationships, and which way the arrows are going to point when you do that are not clear either. I think what you saw here was unique. Having Chief Arredondo step across that line as chief of police was unique. That made a huge difference, more than, in my view, any expert we could have called on use of force. Was what the rank and file police officers, the police trainers, had to say about proper policing mattered most. So those are, to me, some of the factors that mattered. The private bar being brought into the case, the focus on the medical causation aspect of it, the chief of police made a huge difference, and the courage of our attorney general, I think, were all unique here in Minnesota in the Derek Chauvin trial.
So Jerry, there's a question about the jury. Did you and the team get a chance to speak with the jury to see what about the trial resonated most with them? What facts that matter?
No, we haven't. We haven't spoken to the jury, and anything we've heard from about the jurors have been the things that have been on television. Everybody has seen to find out what resonated with them. You know, I would. You can read a whole lot into the amount of time the jury spent in deliberations, which wasn't long at all. That a fair amount of it resonated with the jury, and I think they said that they were, from what I heard on some of the public accounts, they were virtually unanimous right off the bat in deliberations. And there was one person on the jury who said, let's slow it down and go through every question anyway. Not that they felt differently, it was a process issue. And it said, so that's what they did, and that's what took the time it took. But it was pretty lights out for the jury from the start on this verdict.
There's a question about the witnesses that you all called, and it's how did you prepare the witnesses for the testimony? You know, they come in, just as you mentioned, regular community folks trying to do right, didn't know about medical evidence and some of the big terms used in the trial. How did you all prepare the witnesses who, in fact, dealt with something quite emotional, just not innocent bystanders, right? So it hit them where they lived. They saw what happened and were affected emotionally as well.
Mm-hmm. You know, most of that process, particularly with the bystanders, was a process of just getting them comfortable, just telling their stories, not attempting to shoehorn it or sand it in any way. Just come in and just tell their stories, and to know kind of what to expect. I did not think that the defense would spend a lot of time trying to cross-examine any of them because I didn't see what the bystanders had to say as being all that helpful to the defense. They probably want to get them off as soon as possible with respect to all of them. So the process was essentially, let's hear the story. All right, here's then what we'll ask so that now we can elicit this story in the testimony. You know, when I think about any sort of mistakes made with the bystanders, whatnot, I don't think that I probably didn't see one, but with Darnella Frazier, who was the 17-year-old who actually videoed this, and it was her video that went viral. I would love to have asked her during her direct exam how this incident had impacted her life, but the judge would never let me do that since her life and the impact it had on her life was not directly relevant, at least to the principal case. But the defense lawyer made a point in his cross-examination of trying to suggest that her video going viral and seeking the limelight was a part of what she was seeking for her own life in this. And he sort of painted this picture. Well, since he brought it up, now thank you for asking, for bringing up how this impacted her life. Now she can really tell the jury how this impacted her life. And then she gave, I thought, some of the most poignant testimony for how this had impacted her life and how she saw her father, her uncles, and George Floyd, and how deeply aggrieved she was, thinking about what she could have done to have made a difference. But then she said, it's not about what I should have done, it's what he should have done, you know, pointing toward Derek Chauvin. And I thought that was a slip for the defense that allowed us to drive in some really powerful testimony. But in terms of preparing the regular folks, the bystanders, it was just getting them comfortable to come in and tell their stories. And it wasn't easy. I mean, we resisted cameras in the courtroom. We opposed it initially, didn't want it. And we didn't want the cameras in the courtroom, not because we didn't want the public to see, it's because we were concerned that it might affect the willingness of the bystanders to testify. If you get up and tell your truth and then you get attacked from people all over the world, or you're joked about in social media, I mean, that can be really intimidating for witnesses.
Something you said in the conversation with Professors Jones and Lovelace, you said you made an effort not to make it about policing in general, but about the behavior of Officer Chauvin. Given the other cases, someone mentioned in your conversation that have happened all around the country, is it about policing? Is it something about policing that's common around the country that you could say coming out of this trial?
Well, you hear the debates that are happening all over the country around the nature of policing, the culture of policing, the values of policing, some of the training of the policing that you can hear in case after case around the country. You know, there are certain police departments that are steeped or trained in so-called warrior training, where the attitude that's inculcated is that the public is a they, and they are out to get us. And we have to prepare to roll on them to defend ourselves. And so you then show up, officers steeped in this will show up at various scenes already amped up. And there is a view around the country that this type of warrior training results in far more excessive force cases, far more death in custody cases because of the way that the police are trained. By the time you get to trial, there's never going to be a police department on trial. And there will always be citizens who take issue with a broad scale attack on all police. And if a trial ever becomes a referendum on that, you lose. I mean, I hardly ever see a referendum that everybody agrees with on anything. There can't even be a referendum on whether you should take a vaccine against the coronavirus. Even if 600,000 people are dead, there is no referendum. If you have a trial, it's a referendum on that, you lose. So as just as a practitioner trial lawyer, that if the trial is viewed as a referendum on all policing, that's very dangerous. If it's a referendum on race, that's very dangerous too. Because you're not likely to get all the jurors to agree on any referendum. and what's really before the jury is the conduct of a given particular officer. So but the question you raise, Professor Haney, is one that's been asked all over the country now about how do we reform police and policing in general. Here in St. Paul and Ramsey County, for example, the Ramsey County attorney, which is in St. Paul, Minnesota, just said that his office will stop prosecuting some of these minor traffic violation stops. He said because of how they result in the use of such excessive force, and these are my words, not his, but essentially trumped up kinds of charges, predominantly against communities of color, and said they will stop doing it. And there's a real debate going on now in St. Paul, kind of over that, on the extent to which police are preying on certain communities by the undue focus on them. So. Is there something wrong with policing all over the country? It's any person's opinion, but I do know that there is that debate going on all over the country, and there's an issue. This issue exists all over the country.
Thank you. So this is a question, looks like from a law student. Is there a book or treatise that helps sharpen your advocacy skills the most that you would recommend to law students or attorneys?
That's a good question, because I think I probably have looked at all of them that I could get my hands on over the years. I mean, Maue was back in the day, I think MAUET was a good one back in the day that I looked at a gazillion years ago. But what I can say, if you want to strengthen and sharpen your trial advocacy skills, there is nothing like just getting on your feet. Get on your feet, get up and practice, and watch. Go out of the way to watch good practitioners. I mean, I myself am an absolute patchwork quilt of all of the good practitioners I have seen, from which I've taken little pieces from all of them. And then I put it on and wear it like it's my original creation, but it's a reflection of like so many that I have taken and learned from. And that's the best thing you can do. I think in trial ad, if you can't get into a trial, just get on your feet and speak. Get up in front of people. Get comfortable in your own skin, because in my view, the most persuasive trial lawyer is one who's A, prepared, but then B, can be his or her most authentic self. Just be kind of who you are, because some lawyers who get up with this sort of a false perfectionism, where every hair is in place and every this and that, are so afraid of ever misspeaking or misstepping or miss something that they just dim themselves down to an absolute boring mess. And the jurors don't relate to you at all, because they're not perfect people. They're just regular folks. And so I think the more you can get up in front of people and speak, things will happen to you. Your PowerPoint won't work from time to time. Projector won't come on. All sorts of things. And then you realize you survive it all. You survive it. You were just fine. And the more you get comfortable with the fact that you are all right and you will be all right, then that translates into talking in front of a jury. You'll still be nervous, because you got a lot riding on you when somebody has trusted you to speak on their behalf. You'll be nervous, but you'll be all right. And that for me is more valuable. You can learn the rules, study the rules, practice the rules, but the advocacy, I think, is best learned. Just get up on your feet and practice the speaking, and get into court as often as you can.
Two questions left, Jerry. Do you think the social movement activity, the protest for justice for Mr. Floyd, contributed to the case's outcome?
Well, the jurors had said that they weren't influenced by any of that. That was certainly asked of them, and that was a big part of the jury selection and the voir dire. So I have to say no, that I don't think that influenced the thinking or the actions of the jury. I think they decided it based on kind of what it is they saw and heard. The defense was concerned that the entire context and environment for the trial, be it the social movement aspect of it, a courthouse that was surrounded by razor wire with 100 National Guardsmen and other sheriff's deputies, that all of this kind of hyped up the concerns about the security aspect, and they were concerned that that would lead the jurors to convict, so that you didn't have this kind of an outburst. And the jurors were polled on this sort of thing time and again to make sure they weren't being influenced that way. So I would say no, that they did not per se influence how the jurors perceived or saw the evidence, although it was impossible to find a juror who was not aware of it. I mean, that was part of the argument before trial is all these jurors that kind of know about this and know about Black Lives Matters, they know, and arguing is you'd have to be under a rock in Borneo not to have heard about the trial or be aware of it. That can't be the standard. It's whether that's going to unduly influence their thinking about the trial. So I didn't see any evidence that did per se influence how they evaluated the evidence.
Jerry, let me end with a question about you in this regard, and that is, what have been some of the consequences for you professionally, having been a participant in this trial?
It's been the whole gamut. On the one hand, during the trial, I had I didn't look at the news during the trial because I didn't want the news stories in my head at all, and I stayed away from Twitter for the same reason. But occasionally I would hear, or somebody would tell me what kind of messages I would get. And some of them, overwhelmingly, they were supportive, but you get those that are telling me where to go back to. And they didn't mean Minnesota, North Carolina, from where I should go back to. And there were some that were more threatening in terms of what they wanted to do to yours truly. And I had to have an armed security detail. That was all a part of it. Couldn't live at home while this was going on because of the physical threats. So that's on the one end. On the other hand, though, I've had a really kind of privileged, almost blessed seat to be able to hear from people from all over the world who were inspired by the verdict, for whom the verdict meant something for them as they struggle with their own challenges with policing, with race in all parts of the world. As I mentioned before, I mean, I heard from Sweden to Turkey to Peru to Jordan. And if I could tell just this quick story, because this was at least was a funny one to me. We live in the metro of Minneapolis, but we have a farm out in greater Minnesota, in Jordan, Minnesota, about 40 acres. And it's fairly non-diverse town. And in some ways, in where our farm is, we are the diversity over there. And believe you me, it was like we moved out to Green Acres. And guess who moved to Green Acres? And so very conservative place. I mean, I got hundreds and hundreds of congratulatory notes from all over the world, but where the farm is, I got one. One note of congratulations. That was one more than I thought I would get. And the rest of the neighbors, even the very nice ones, the most they'd say is, we saw you on TV. And that's the end of the discussion. And so a kid from the high school, and we have scholarships down at the high school because I want to support the community. We're trying to do our part in this community, and we support scholarships in the high school. So this kid, his name was let's say Basil Al Hussein was the name, and he sent a note saying, could you just give me 15 minutes? I've got to do a book report on my hero, and you're my hero, please, just 15 minutes. So I saw this. My secretary said, "My God, Basil Al Hussein is in Jordan, Minnesota. Oh wow, his family must be having a tough go of it there. Let's try to help support this interview, and we'll do it." So we set it up, and then he sends an email back and says, "What time zone are you in?" And and I realized, he's not in Jordan, Minnesota. He's in the big Jordan, in the country of Jordan, and watching the trial. And so I did interview with a young man in the country of Jordan, after all, and laughed at kind of how that came about. But it's because there was so much interest and support for it. And he said, you wouldn't believe just how popular the various members of the trial are in Jordan as they watched it. They said every day and tuned in, or it was translated in Thai in Thailand and what have you, French in West Africa. So it to me was it was a privileged seat to be able to see how it inspired so many, and in ways that so many of the rest of us would not be able to see from folks who were from all over the diaspora that were writing in and saying that it meant something to them. So I was grateful for that, and overall, it was a blessing to have been able to serve this way. And I could say, when all was said and done, that I did hear a call to serve this way, and I was grateful to have been able to answer it.
Thank you, Jerry. Wow, this has been great. I want to thank the audience for participating. Professors Jones and Lovelace, thank you so much. And Jerry, we're sorry we couldn't have you here in person, because we want the audience to know this was planned to be an in-person event. But as we know, we've erred on the side of caution and safety in the midst of an ongoing pandemic. Let's all be careful, wear our masks, stay distance, and help this thing be in the rearview mirror pretty soon. Thank you, my dear friend, for joining us at Duke for this wonderful event. Thank you so much, and thanks to all. And good night, everybody.
Thank you all.